Recording. This professional studies lecture is highly relevant to the current situation of where we currently are in terms of architects, builders, and contracts. It is only an introduction to the whole contract, for the depth of the contracts. You'd be looking at your masters and your professional practice examination in however many years time it's going to be to become registered architects. So this is only an introduction, but it's dealing with a couple of clauses that are really, really super relevant right now. So let me get rid of Vectorworks. I can quit out of that. Let's save and quit out of that. And then I'm going to open up my PowerPoint slideshow on this, make sure I've got it there ready to rumble, and set up slideshow, define individual, okay, and slideshow from start. There's my slideshow. Bear with me while I get it set. Okay, and then I go back to Zoom, share screen, and that one. Can everybody see a PowerPoint slideshow with professional studies, contracts? Quick thumbs up. Perfect. So this is one part of a contract that, say if building is going on right now, and then suddenly they say a week ago on Friday, all construction must stop. Where does that leave the contract between the contractor and the employer? That's your client, remember. But in this contract sense and during construction, it is called, he or she is called your employer. Where does that leave the contract, and what is that? And that is what the force majeure is. It is a French word. Think of it as major force. Okay. So the contract, so I've been restricted by what I've got in the house because I'm now at home. This is a fairly tatty one. And I remember we did this in semester 1, but I'm just going to recap it just to go through it a little bit of detail. In that, let me just move over that. So this is the actual contract. This is the articles of agreement between your employer, that's the contractor, your client, and the contractor, that's the builder. It's really straightforward. So from the top, articles of agreement, and this one is one where bills of quantities do not form part of the contract. So you could have one where they do form part of the contract, and you could have a short form. It's called an SF88. There's also a white form, and they come in different colors. And so it's really nice and slowly, and we'll go through it. The articles of agreement made between the fill-in on the date between whose registered office is, that's their address, hereinafter called the employer. That is effectively your client. That's the employer. And the next part is the contractor. That's effectively the builder. Whereas the employer is desirous of, that's the works of what that you're going to build, a new house in Sligo, hereinafter called the works at the address, and has caused drawings, hereinafter called the contract drawings, and a specification describing the works to be done of, that's the architect, your name. And whereas the contractor has made an estimate of the sum on this tender date here, and schedule of rates is here, and the contract drawings are numbered here. It is hereby agreed that, here's the key bit, the employer will pay the contractor the sum of, that's the amount. There it is written, and there it is in numbers. This is the contract sum. So you have an offer and you have an acceptance, and that forms the contract. All the parts after that are going to be the conditions of the contract. So we're going to move on. So last Friday, all but construction stops. This is clause 30 of, and this is, we're going to see the other contracts where this is not included. This is the RIAI contracts, and it's in this, a section called delay and extension of time. So 30, if in the opinion of the architect, the works are delayed, in this case, they've been stopped completely, so it's obviously been delayed, by a force majeure, or that's the one we're going to look at today. I'll quickly go through the other ones because the contractor didn't get possession of the site quick enough. C, exceptionally inclement weather. That is exceptional, not just a bit of rain in Sligo. That is something that is seasonally absolutely exceptional. Reason of loss or damage to the works or ancillary items. Reason of civil commotion, local combination of workmen, strike or lockout. E, F, by reason of any architect's instructions. If I delay it by giving instructions that it causes extra work or time of the contract, then that's a reason. G, because the contractor has not received in due time necessary instructions from the architect for which he has specifically applied for in writing. These are all reasons why that a contract time can be delayed and the contractor will be allowed an extension of time. The one we're going to look at now is a force majeure. So the previous slide, these are the reasons. So let me just hold up here. I dug out from the attic. Bear with me a second. I dug out from the attic my old copies of different contracts. So I've taken them out from this. That's where I've taken them out from. The previous slide, G, I haven't finished these yet. H, because the contractor or nominated subcontractor or nominated supplier has been unable for reasons beyond his control to secure labor and materials. That's H. I, by delay on the part of other contractors, artists or tradesmen engaged by the employer in executing work not forming part of this contract. That means if there's other people on site, like contractors, artists, that are directly engaged by your client, employer, then the subcontractors, and they delay everything. The contractors entitled to delay on those terms. And J, by reason of any act or default by the employer causing delay. So we're looking at the force majeure on A. That's what we're going to look at now. Now, this is just an introduction, as I said. So this is the type of thing that you will get heavily involved in after you've done your degree. You've had a year working. You're going to do your master's, 2 years, another year working, and then you'll start to thinking about your professional practice examinations. In the UK, it's called RIBA Part 3. And in Ireland, it's called the Professional Practice Examination, which is currently, I think there's only one at the moment. It's currently taught at UCD. I was doing a couple of lectures last year for that. So, this topic, these types of topics where you're working in contracts and understanding the contract clauses and the sequence, this is what your Part 3, your professional practice, is about. This is the legal requirements in order for you to practice safely as an architect, that you require to be showing that you are able to do this type of work. So some people will love it and some people will absolutely hate getting involved in contracts, and they just want to do drawings. They don't want to get involved in any of this. So this is an introduction. So if there is a force majeure, then we're at the sentence after J. Then in any such case, the architect shall, as soon as it is possible for him or her to do so, make a fair and reasonable extension of time for completion of the works. We're going to look in the sequence and order of this in a second. Upon the happening of any such event causing delay, The contractor shall immediately give notice thereof in writing to the architect, but he shall nevertheless use constantly his best endeavours to prevent delay and to proceed with the works. In determining what extension of time, if any, is fair and reasonable, under paragraph D, for loss or damage to the works or ancillary items, the architect shall have regard in particular to any negligence, omission, or default of the contractor which caused or contributed thereto. So the architect has to keep an eye on this. We're going to go through in detail what that sequence of events is. But what exactly is a force majeure? Here we go. And this was the Bible for when I was going through the part 3 notes, professional practice in Ireland. I think it's out of print. I don't know whether you can get copies of it for when you do part 3, if you're ever doing it in Ireland, but this is the book here. It is the RIAI contracts, a working guide. This is the 4th revised edition. David Keane, if it's still in print, it goes through. You can see all my highlighting there of different bits of going through all the contracts. Some of these are going to be out of date, but some of the case clauses are highly, highly relevant, and they're still relevant. And the principles of what a force majeure is and what delays are and the way a contract runs, this is a highly recommended book when you get to that point. So what is a force majeure? If, in the opinion of the architect, the work be delayed by a force majeure has been defined as something which is outside the control of the parties to the contract. So it's outside of anything that the contractor did or the employer did, and implying the use of force of such strength that the works could be delayed or even stopped. That's what's happened this Friday. The works have been stopped. I would never think I would be giving this lecture on the force majeure with the instances that have happened since the last couple of months and everything stopping in Ireland. Examples, and these are my highlights from when I was doing this in 2003, I think. Examples might be acts of God, i.e. earthquakes, or look at that word that I highlighted, epidemics. They didn't even have pandemic in there. It just had a normal epidemic. They never even realized that a pandemic would even go into these notes. Government actions such as curfews, general strikes, or even prolonged electricity strikes might also rank as a force majeure. So that's the situation we're in. Not even an epidemic, we're in a pandemic. So these are the procedural requirements. So I've just taken out from David Keane's book, having set out those 10 headings, and the one we were looking at is force majeure. Then in any case, the architect should, as soon as possible, make a fair and reasonable extension of time. So the architect gives the extension of time. It's something that is fair and reasonable. So the procedural requirements are this. This is step by step by step. And remember, this is only the RIAI contract. We're looking at the other contracts in a minute. The procedural requirements of this paragraph are: the contractor is required to notify the architect upon the happening of any event. So any contracts that are in place at the moment, the contractor should have written to the to the employer and the architect, write to the architect and say that this event is happening, and the reason why it's happening is because of this force majeure situation. This is obviously, hold on, Tiffany, sorry. Hey, Tiffany, sorry, added you in. So the procedural requirements are, number one, the contractor is required to notify the architect upon the happening of any event. So obviously the architect needs to know that this is happening. We know now because the pandemic's happening, but if it's something that was on the other side of the country and it was exceptional weather there, then they might not know, but we all know, but it is still required for the contractor to notify the architect of what's happening at the moment. This is essential, as it is necessary for the architect to know immediately if an event has occurred which might occasion a delay, so as to enable him or her to judge a fair and reasonable extension, if appropriate, before this delay becomes swallowed up in the general program. So there might be other delays for different things. So this specific event, it should have a specific letter that says this is a force majeure event. Number two, the contractor must minimize any delay. It is a requirement in ordinary law that a person mitigate his damages, and the contractor must therefore ensure that he can show that he has taken all steps available to reduce any delays caused. I can't see what could have happened from Friday that what he could have done to minimize any delay at that point. So we're now in the hands of God, and obviously social distancing and washing our hands in order how long this is going to take to go. 3, the architect shall make a fair and reasonable decision as soon as possible. So the letter comes from the contractor to the architect about the force majeure. In this regard, the architect will not be acting purely as an agent of the employer. So it's exactly the same as when the contract is signed between the contractor and the employer, that the architect is balanced between the two. He's not working for the employer, your contract side. He's not working on the contractor side either. He has to be working unbiased between the two. He must decide the rights of the parties under the contract. So both impartially and independently. It used to be thought that when acting in this capacity, the architect was performing a quasi-arbitrable role and that he was immune from any claims of negligence. So you need to be very careful here in that you're still adhering to the usual standard of skill and care of what is expected of the general architect as a professional. And then there's an actual case reference there, the Sutcliffe case. Gives you a paragraph reference if you want to look this up in more detail. Then number 4, the architect shall consider the conduct of the contractor as far as paragraph D is concerned. So we need to make sure that the contractor has done all steps to minimize delay, and the architect shall have regard in particular to any negligence, omission, or default of the contractor which caused or contributed thereof to the delay. But in this instance, it's a force majeure. There's nothing he could have done about it. He's not negligent. He hasn't omitted anything. He hasn't defaulted on anything. So we're moving on from that. That's the sequence of events. So let me now stop that for a moment, and I'm going to switch over now to some PDFs that I've opened, and let me get rid of that one and get rid of that one. So I'm going to make sure that these PDFs are going to be on screen, and let me get them in order first. I've got force majeure. Bear with me while I get force majeure 2, and bear with me while I get it all up. I've also got here a picture to show you as well, which I don't think I've saved. So I'm just going to open it up, and then I'm going to start sharing again. 2020 lectures, professional studies, table. Here we go. It can take a second for that to open. Right, here we go. So back to PowerPoint, back to Zoom, share screen, and we're going to share. Bear with me, sorry. Reader. Okay. So, force majeure. And Zoom. Share screen. Force majeure. Sure. Can everybody see on the screen COVID-19 to a force majeure outbreak? Perfect. That's good. So I'm going to give you this this document, and it summarizes some of the things that I've said a moment ago. Let me just make it a little bit smaller so I can read the thing without all the chat stuff. And so such contracts will, between an employer and a contractor, will often contain a force majeure clause, which in most cases will be defined along the following terms. Any event beyond a party's reasonable control could not have been foreseen, correct. This couldn't have been foreseen and it was not unavoidable, which prevent or hinders a delay for this to happening. Many of these clauses go on to list examples of force majeure. Events include the outbreak of war, terrorism, strikes, acts of God, and crucially, here we go, epidemics or pandemics. Now that the World Health Organization has declared that it is a pandemic, and it's easier to satisfy this as a triggering event, so there's no arguing that this is a triggering event for a force majeure if the contract has it. There is no doctrine of force majeure in Irish law. It's actually a French word, as I said. So where there is a force majeure clause in the contract, it would necessitate an analysis of the contract. So some of the contracts I'm going to show you are going to have this clause in them, and some of them are not. So my advice for this is that if you're working with contracts, that you're going to have to take legal advice. People, bodies such as the RIAI and the Construction Industry Federation, CIF, are going to give advice, and solicitors and lawyers are going to give advice on how your contract stacks up in terms of a delay or extension of time relating to a force majeure clause. So the consequences of a party successfully invoking this would be a suspension of or relief from the party's obligations of the contract. That's almost certainly going to happen on RIAI contracts because it's suspended at that point. The builder can't go back to work. We don't know when we're starting back. So at this point now, the party's obligations have been suspended. Any delays that the builder will have now will not lead to any liability. He's not going to have any penalty clauses against him being able to be enacted upon him because of this force majeure. Any extensions of time will be granted because we need extra time to finish the contract. There may be a renegotiation of terms, and there may be the right to terminate the contract after a period of time. What happens if we don't go back to work again within a year? At some point, if that doesn't happen, then the contract has got to be terminated. And so table 3 now is, and is covered in public procurement. Table 3 has, I'm going to just open that up for you. I'm going to stop the share on this, and I'm going to share now the table 3 for this. Share screen, and this one, share. You should now see on your screen a breakdown of typical contracts. Quick thumbs up that you can see the RI on the screen now is RIAI, PW is Public Works. These are the two I'm looking at now. I don't get involved in PPP contracts, or I don't get involved in FIDIC contracts, but presumably for when you take your practice examination, you may need to know them. I don't get involved with them, the work I do. I get involved in the RII contract and PW for Public Works. I'm going to show you the minor works public works contract in a minute. So RII. The RII contract does allow grounds for delay because of a force majeure. They're going to call it an FM here. So it may be possible for a party to raise this as a force majeure event. And I showed you the contract clause, and here it is here summarized again. If in the opinion of the architect, the works will be delayed by the force majeure, then the architect shall as soon as possible make a fair and reasonable extension of time and EOT for the completion of the works. Upon the happening of the delay event, the contractor is obliged to immediately give written notice to the architect and shall use constantly its best endeavours to prevent delay and to proceed with the works. They can't proceed, it's stopped. In determining the extension of time, the architect shall have regard to any negligence, omission or default which the contractor caused or contributed to. So the architect needs to keep their wits about them in case there's other stuff going on that's separate to the extension of time relating to the force majeure. One point to note is that the force majeure is not defined under the standard form of RII contract, and this standard form is frequently amended, and so a party should consider the terms of the specific contract. So whatever specific contract is used, you would need legal advice to see whether a force majeure counts and is included in there as a triggering event. Now, Public Works CF1 for contract. It appears there may be a difficulty in raising COVID-19 under PWCF1. I'm going to show you a Public Works contract in a minute. I'm going to look at it in a little bit of detail. Clause 3.1 states that the employer shall bear the risk of loss from these things: war, invasion, rebellion. This is it on PWCF1. 1, 2, pressure waves caused by aircraft, radioactive contamination, terrorism, use of occupation of the works by the employer other than provided for in the contract, and design of the works by the employer. So there's nothing in that on the Public Works contract that includes force majeure. I'm going to explain that again in a little bit. The schedule to this contract outlines what qualifies as a delay event, and the list does not include force majeure. Therefore, a contractor may be in difficulty in seeking to rely on this coronavirus COVID-19 for an extension of time claim. So there's a lot of architects that are going to be having to deal with contracts and trying to struggle through this, and the contractors are also, if they're doing public works, it's going to be an interesting situation. I may come back to you in a few months on this to see what other architects have done in relation to public works contracts. There is a delay event for delay brought about by order or other act of a court or other public authority. Therefore, delay caused by, example, lockdown measures instructed by government could constitute it. My guess is, I think it'd be very hard in a public works contract for force majeure not to be acknowledged in that contract for an extension of time. But who knows what's going to happen. And I'm not even going to discuss the other two. It may be possible in the FIDIC Red Book. It also appears there may be a difficulty in the PPP contract. So let me stop that one. Go back to Acrobat again, and all of these documents, I'm going to make sure that they're in there, that you're going to be included. That's force majeure file 2. And let me share this one. Zoom and share screen. That one. So you should now also see on your screen, it's going to be a little bit smaller so I can read it. Quick thumbs up that you can now see on your screen contractual considerations in the face of COVID-19, force majeure, and this word frustration. I think we're all suffering from frustration. So again, this is another summary of a force majeure. So the general principle is that there is an offer and an acceptance, and that's your contract between the employer and your contractor. And so when one party fails to perform its obligations, that obviously breaks the contract. So, so what we've got here is something that's beyond their control, and provides a defense to the non-performance of contractual obligations. So it allows us to excuse the builder from finishing the works on the time that they required to be finished on. Its roots are actually in French law. That's why it's a French word. And it has no prescribed meaning under Irish law. So, as I said, keep saying you're going to have to take advice from your solicitor in terms of the way the contract's drafted. Because force majeure clauses are the product of negotiation, the way in which they are drafted tends to differ from contract to contract. And we've seen those. I showed you 4. That's 4 basic ones. That's not the detail of the RIAA ones, or the public works ones, or the other ones. There's 4 or 5 of each type. So each contract could have specifically different clauses relating to acts of God, of flood, drought, natural disaster, epidemic, or pandemic. So the actual precise wording of the contract is critical to this. So, as I said, the wording is really, really important. So the doctrine of frustration may provide an alternative means of protection for the contractor. Under the doctrine of frustration, the contract may be discharged, i.e. stopped, when something occurs which makes it physically or commercially impossible to fulfill the contract. It radically alters the obligations that the parties agree to undertake. So that's really what's happening now as well, in that this concept of work stopping, that it is now impossible for the contract to be fulfilled, and frustration of a contract will often result in the contract being discharged, and the performance cannot be reactivated until the frustrating event, i.e. the lockdown on work, is stopped. So even if there isn't a force majeure, frustration is explained there in that paragraph. So while rarely used in ordinary circumstances, this is the first lecture I've actually given in detail on what the force majeure is. It could be one of the most relevant ways to mitigate this, the consequences from fulfilling the contract. So you need to consider the wording of the clause, the intentions of the party, and the overall contractual agreements. So that's another document I'm going to make sure that you can have a read through after this lecture. I'm going to stop the share on that, and then I'm going to go back to the PowerPoint slideshow. And bear with me while I share it again. Zoom and share screen, and that one and that one. So you should now see on your screen public works contracts. Quick thumbs up to see that you can see on your screen. Perfect, Tina. Thank you very much. So public works contracts. I'm gonna give you one as a download so you can see what a full contract looks like. The public works contracts are works where you're working for institutions such as county councils, city councils. So the one that I'm going to send to you as an upload is the one that we used on the projects we did for Galway City Council, and it's a public works minor works contract. It's up to a value, I think, of 100,000. It's a small contract. There's a bigger one for bigger works. So the words in that contract, and you can have a look to see if you can find it. I couldn't find it. The words force majeure do not appear in the public work contract. There are provisions under clauses 9 and 10. So I'm going to open it up and I'm just going to scribble, make sure that I get to 9 and 10 in a minute. And that clause 1.2.2 notes that references to delay events, and there may be a list of events that might lead to a claim of a time extension by the contractor. So here's the key paragraph. Legal opinion will sought by the CIF. That's the representative body of builders, the Construction Industry Federation, and building contractors, to ascertain if the equivalent of a force majeure can be applied to any of the events scheduled in this schedule in the contract. So bear with me while I open up stop the share on that one. And now I'm going to go over to the actual contract itself. Let's get rid of that one. Make that screen a bit smaller. And go to the top and share this one. Share screen. Public Works contract. So this is an actual Public Works contract. So you can actually see what it looks like. Quick thumbs up. Can you see at the top of this Public Works contract for minor works? Everybody see that? Excellent. So Public Works contract for minor building and civil engineering works designed by the employer. I'm going to go through it. As I said, the part 3 RIBA in your professional practice examination will go through this in a lot more detail. This is an introduction. So you have the contract itself, and I'm going to show you an acceptance document in a minute where the builder has accepted the terms of the contract. The contract is defined, how it's interpreted, the pricing document and what we're going to do, what the builder's going to do, gives you a little bit of law, Safety, Health and Welfare at Work Act. We've done loads of that when we've done the lectures on the PSDP and the PSCS. It goes through loss, damage and injury. If anything gets damaged on the works, how the works are insured, what indemnities there are for the contractor and the employer, what the insurances are in terms of public liability, professional indemnity insurance, using existing facilities, a load of stuff about management. This word here, employer's representative. So on a public works contract, I'm the architect, and I've formed a team that included, in my design team, I included the architect, me, the PSDP, the project supervisor design process, that was also me, the structural engineer, the quantity surveyor, and the mechanical and electrical engineer. But the employer's representative is a separate person, which is me also, that is the representative of the client when there's any discussion on what needs to happen. So I'm representing the employer. In this case, it was the city council. Different contractors' personnel relating to subcontractors on site, ownership of different materials as the materials that are on the site, the site, lands made available for the works, trespassing, setting out the works. When we get to part 3, we'll have if you have any questions on that, give me a shout, and however many years it is. We went through in a previous one about the defects liability period, when the project's going to start, delay and extension of time, 9.3. So this is where we're going to come back to that. I'm just going to scribble it down so I don't lose it in a minute. 9.3. And we went through in a previous lecture about substantial completion, liquidated damages. If the builder doesn't finish the works by a specific date, then liquidated damages are like the penalties he has to pay. And what he's trying to get out of is paying those penalties because there's a delay caused by the force majeure. Contractors' claims, I might do that when we get back after Easter about claims. I don't think we're going to cover that today. Payment, we went through in a previous lecture about the retention percentage, about the full payment, the final statement of account, the time for payment, and withholding tax. This is interesting. The last couple of years I've been working on public works contracts, and that when a public works contract is in place, the contractor doesn't charge VAT, value-added tax, to the employer, and I don't charge it either. It's basically when I get paid my invoice from a council, they withhold money for tax purposes, which I claim back at the end of the year. And the builder's doing the same thing. And that it's when you get your bill paid, a heap of money's been taken off, but it's like Christmas at the end of the year when you get a heap of money back in that tax that's been withheld. How the contract's terminated, that's going to be interesting when that kicks off after the force majeure, if things don't pick up. If there's any disputes, adjudication, arbitration, hopefully everything's going to get sorted out after all of this and we don't have to go to either of these. Arbitration, price variation. So the bit that, and then we go through the conditions of all of these contracts. So these are that's the principle of it. And then we skip through. I'm going to go through this, skip it through, until I get to clause 9.3. So you're free to read all of this contract. I'm going to make sure it's accessible to you. What I'm going to do is move that to the right and then just scroll down here. Where are we? 9.3. 9.3, 5555555. And so your part 3, you're going to have to be expected to know how the contract is administered, and you could be asked a question on one of these clauses. Here we go, delay and expedition. And remember, I think I told you before, my part 3 examination in the UK, and it's all lovey-dovey when we sat down, and I sat down and I, how Mark, how are you? And they said, right, clause 9.3.1, you said this in your written exam. What did you mean by that? And da-di-da-di-da. It was an horrendous experience. I came out of the exam and I threw up straight away. So this is 9.3.1. If the contractor becomes aware that work under the contract is being or likely to be delayed, yes it is, it stopped because of the pandemic, it shall, as soon as practical, notify the employer's representative of the delay in its cause. In this instance, it would have been me. The contract's actually nearly over, but there will be a delay. I haven't heard anything yet because it's all been shut down. As soon as practicable after that, within 40 working days, so I have a 40-day period after the contractor became aware of the delay, the contractor shall give the employer's representative full details of the delay, its effect on the progress of the works. So he's got to tell me the full details, what the effect is on the progress of completing. But if the contractor has given notice and details of the delay under this other clause, it does not have to give notice or details again for the same delay. So we're looking at a different one-off delay here at the moment. Then we've got 9.3.2. These are what's called a delay event. And all it says is, if substantial completion of the works or any section has been or is being or will be delayed beyond the date for substantial completion, the delay event is not a result of the contractor's or contractor's personnel's act or omission. The contractor makes all reasonable efforts to avoid and minimize the delay. The contract does not prove otherwise. There shall be an extension of time to the date of the delay. Even though it does not specifically state that the force majeure is there, if I was a lawyer, and I'm not, so take legal advice, the delay event is not a result of the contractor. It is separate to that. It's something beyond his control. I would see it being very difficult for an architect or an employer to say, you should have finished by this date, and we're implementing the clause of the contract and penalty clauses. I find it very difficult for that to be the case, because this is way, way, way beyond their control. And we scroll through, and there's a load more time about substantial completion. So have a good read through of that when you get to that. So that's the actual contract itself. Let me see now. I'm going to stop the share on that one and go back to Reader, and that's the contract there. And bear with me while I get the letter of acceptance. Don't panic, I've not got it. So this, I'm going to include this as well. This is, so that's the contract. Remember the process, so I'm going to just make sure that you share this as well. Share screen and letter of acceptance. Here we go. Can everybody see the top of the page, letter of acceptance? A quick thumbs up. Perfect, Ina and Connor. Thank you very much. Can you remember the process from a few weeks ago before all of this mess that we had, we went through the process of e-tenders. So the contractors are looking for projects. They then tender and fill in all the forms that need to be filled in to win the project. They may be going up against 4, 5, 6 other contractors. And when they have the lowest price, all the tenders are opened at the same time on the same day, and they're analyzed. The employer's quantity surveyor will go through the prices and see what's the lowest price. The letter then is sent from the employer to the contractor as a letter of acceptance. On the basis that the contract performed, I set out your tender, this letter of acceptance, the agreement that we saw, the conditions of the public works contract, the tender and schedule appended to this. So this is the tender and schedule. I've taken out their dates, but it's got the projects here that I worked on. And tender, this is who it was for the attention of, date, this is the project. Here is the amount. It's exactly the same as the RIAI contract. You have an offer, an acceptance, you're desirous of the works, and this is the amount of money that's going to be passed over from to do the works. It's acceptance of the contract, signed on by the tenderer, that's the person, that's the contractor, and as a witness, signed, or if the tenderer is an individual, if it's one person, this is a company, signed on behalf of, this is a load of other signatures, but we don't get involved in those, this is not relevant. This is the schedule informing the builder who the employer's representative is, that's me. Limitations on the authority. Documents are the drawings. The pricing document goes through what each price is for specific items in terms of the bill of quantities that our quantity surveyor has put together. Project supervisor, insurance, all the exclusions. Does it say anything in here about force majeure in the tender of acceptance? That would be interesting. Hold on. It says about insurances. It's got pressure waves caused by contamination by radioactivity, terrorism, or asbestos. That's your insurance, but it's not about, it won't have anything in there about delay. Permitted exclusions from insurance. Public liability, no, that's not relevant. That's the project optional insurance things, performance bonds. Let's skip through that. Delay events, compensation events, there's the clauses there. The employer's representative gives the contractor a change order. So change order, we might do that when we get back after Easter. That it's not a change order. And I can show you change orders. I went through them a bit, but we're going to go through them again later. The employer's representative directs the contractor to search for defects. No, not done that. The employer's representative directs the contractor to suspend work. I haven't directed him to suspend work yet. The government has, but I haven't. The contractor suspends work in accordance with subclause 12.3. I'll have a look at 12.3 in a minute. I might come back to you on that. Setting out, no. Substantial completion, no. Instructions, no. No, no, no. Loss of damage. A weather event, no. Strike or lockout, no. Delay to the works caused by an order or other act of a court or other public authority exercising authority under law that did not result of or in connection with an act. That could be it. That's where they're going to start looking in the contract clauses, maybe not in the contract, but in the letter of acceptance. And that is a delay event. So that goes through that. And so and just going to scroll through to the bottom. And I'm going to send this to you as well, so you can have a read through of what the acceptance letter looks like from a builder accepting a project. Let me stop the share on that. And I think that brings us neatly round to the hour on the principles of a force majeure. Now, as I said, this is now your last professional studies lecture, and this morning was your last BST lecture. Is there anything that anybody wants to say before we break for Easter? Is there any questions before we break for Easter? Any questions? Anybody? Not at the minute. Well, Juma, if you do have any questions, my email is always open. It's open to everybody there. If you want to ask anything about what we're doing, anything related to your project, I'm going to ask Bernie and Michael. Let me turn off the recordings. Let's stop that now.